actually working remotely today, clearly. And so if you guys hear any wind or people, or if there's any disturbance whatsoever, my apologies in advance. We are trying to do the best that we can with what we have. So my name is Christina Jimenez.
And I am Josh Floyd.
And we are family law attorneys, criminal defense attorneys at the Jimenez Law Firm. And every Friday we come together and we kind of discuss complex legal issues, different fact patterns and questions that have been presented. And I tell everyone, or each time we do this, I explain that do not take this as legal advice. Okay, so basically we're just talking through fact patterns. And what you'll notice as we are discussing this stuff is that it is very much dependent on the facts in that particular situation. And so it is very, very important that if you ever find yourself in a situation like this, that you contact an attorney of your choosing, somebody who clearly knows what they're doing, more than likely somebody who has practiced in the county where you're having your issues, and listen to their advice. Tell them your story. And perhaps this will give you a little bit of insight as to how things go, but by all means you should not accept this as any sort of legal advice. You need to retain counsel. Okay. And so Floyd, so
how do you feel about them following us on social media?
I feel like that's an exceptional idea, Mr. Floyd. Why don't you discuss that?
Okay, so you can follow us on social media, all of the platforms, Facebook, LinkedIn, TikTok, Instagram, Twitter, at Jimenez Law Firm.
Excellent work. Keon's going to be very proud of you.
He is. You're welcome, Keon.
All right. So with that being said, do you want me to do the first question, or do you want to? Who's going to ask?
I'll ask.
Go for it.
Who do I contact to have withholding for child support terminated? There's already an order to modify the custodial agreement that states that I am now the primary custodian and child support has been terminated. I'm in the military, and DFAS, our accounting service, has said that they need a court order stating the child support is terminated. The order needs to be sent from the court that ordered it in the first place. When I called the court, I was told to contact child support office, who then told me to call the court.
So I guess what he's probably referring to is just the withholding order. So the way that it works in anytime you have a child support order that has been issued is you'll have your main order, right, which is going to be like your final decree of divorce, your suit affecting parent-child relationship, your petition to adjudicate or order on petition to adjudicate parentage. There's all sorts of different orders on suits to modify, orders on suits to confirm arrears, etc. And so that's going to be the main order that is kind of the substantive language of what's supposed to happen. Okay, so I presume in this particular case, there was a final order on suit to modify where it states he doesn't have to pay support anymore. Okay, and that maybe mom's supposed to be paying child support. So it is important to remember that there's a separate document, a couple of separate documents that in this particular case we would typically file. And so one would be an order terminating withholding. And it's basically a fill in the blank. There's a bunch of check boxes and stuff that we put in or fill in. You submit that. And then once the judge signs that order, you have to do a request for issuance. And basically that's a form that you submit to the district clerk's office. And then the district clerk's office will then be charged with forwarding that withholding order to your employer. And then once your employer receives it, they will terminate the withholding. And so I suspect that perhaps that last portion of his case hasn't been handled yet. Is that what you're thinking?
Yeah, I didn't really want this question because it's kind of a PTSD issue for me. A few years ago when I had messed up a case like this. So a similar case, modification, and our client had gotten custody, and we put a child support obligation on the opposing parties, but we didn't put in language in the order that specifically terminated his obligation, right? So we had to go back and redo that, get another order or motion in order to get his obligation terminated so that we actually had an order specifying that his obligation was terminated. So hopefully that language is in your order. If not, then you got to go back to the judge on it. But if there is language specific to terminating your child support, then I think, yeah, you just need the order signed by the judge terminating. The question is going to be is how long has it been? Has the court lost power to sign such a motion or such an order, or are you going to have to file another motion?
I think that they could sign, I don't know that that's a plenary power issue on an order terminating withholding. You think? I don't know that that is.
Oh,
And I think that you could probably, even if it was, maybe just file a separate motion in order to terminate withholding. But I would suspect that the judge would probably just sign it and be done with it, if in fact that main order says that your obligation is terminated. And so it's super, super frustrating. I cannot tell you the number of times that I've had clients like get really, really pissed off because, like this guy, he has his order, right? And it says that his child support obligation is terminated. So these withholding orders, your employer by law has to comply with the withholding order, not your final decree, not your order in suit to modify, the withholding order. And so if that is not done, your employer has probably told you there's nothing that I can do until I get this an order terminating withholding. Similarly, once the order to withhold is presented to your employer to start taking that money out, your employer cannot not take it out because they could actually get in trouble. Like we could file enforcements against them. They could get assessed attorney's fees. There's all sorts of craziness that could happen. And so we actually had that come up in one of our cases a few months ago where our lady wasn't receiving the child support. And so we file an enforcement against the dad saying, hey, this dude's not, paying his child support. So we want to put him in jail. Well, then dad's attorney contacts us and he has a list, or excuse me, his pay records where it's showing that all of this is being deducted from the paycheck. And so we then have to get in contact with the employer, and they figured out that there was some sort of like an administrative error or something, and they had been withdrawing it, but they hadn't been sending it to San Antonio. And so in that particular case, I think it was like $10,000-$12,000, something like that. I basically told the employer, like, you need to make this payment within so many days for the full amount. Otherwise, we're going to probably be suing some sort of an enforcement action against you guys because y'all are not supposed to be making those mistakes. And thankfully, our client got the check like within a couple of days and everything worked out. But don't get pissed off at HR. I think it's the long and short of that, because they're going to take your money because they have to. Otherwise, they'll get in trouble. So what else, Floyd? Anything else?
I don't think so.
All right. Okay, so next question. Do I have to return the gifted gun because we broke up? I was dating this guy for 1.5 years. He bought me a gun for Girlfriend's Day in August of last year.
What is Girlfriend's Day?
It's a day. It is a day. I don't know.
Oh.
There's all sorts of days these days.
Any excuse for a woman to get a gift. Jeez. When's Boyfriend's Day?
We broke up in February and he moved out. But we continued to be very good friends. Within the last 4 days, he has told me I need to give him, quote unquote, his gun. He said he is going to file a stolen gun police report and will get a sheriff to come to my house to get it. But he gave it to me as a gift, and he has moved out for 2.5 months. And he left it at my house when he moved out because he said it was mine. But the gun was left at my house for 2.5 months after he left before he asked for it. So what say you, Floyd? I don't know. This isn't really like a family law question. Right?
It's not really. It's not really. I mean, it can apply, right? Because it applies to divorces the same. Not really, because not. Anyway, no, it's a gift, right? You know, I was going to try to compare it to like separate property gift, but
right.
We're not dealing with community property. There's no need for separate property.
Right.
But anyway, well, so if you're going through a divorce, this would be considered your separate property because it was a gift. Assume that you can satisfy the elements of a gift, which are the exchange and the present intent for it to be a gift at the time. Am I right? I think I'm missing one.
Yeah. No, I think that's it. Exchange, present intent.
Okay. So generally what we would do is, if we had like a picture of you receiving it on your birthday or Christmas or something along those lines to prove that it in fact was a gift, then in a divorce case, this would be a separate property gift and wouldn't be subject to division. But my rule of thumb is, if it's a gift, keep it. Who cares what they say?
I mean, if the sheriff show up at her house, like she might care what they say. No.
Possession's 9/10 of the law, right?
Okay.
Yeah, no. If the sheriff tells you to give it back, you should probably just give it back, and then you can decide whether you want to go through the whole business of suing him over it, which you probably win if you can prove it was a gift. But and there's a big ass cricket that just crawled across the spot.
Oh no, Floyd. I'm glad that it happened to me because I would have ran away.
Kind of freaked me out. Like, what is going on over here?
I was wondering why you were so distracted.
Yeah. Because I thought I saw it at first, and then I looked over, it was gone. Anyways, yeah. So yes, keep it. That's the bottom line.
So I'll say that in divorce cases, a lot of times I will have clients who get all sorts of crazy over something like that. Like, this is my gun that he gifted me for, Mother's Day or whatever, and I am going to keep it. And then the parties start getting into what I perceive just to be a pissing match over a gun that's, maybe worth $400 or $500. And I think that it's important that you all keep perspective when y'all are doing those things, right? And I also think that as attorneys, it's important that we pull our clients back and say, listen, this gun or the attorney's fees to fight over the gun will cost 2 or 3 times as much as what you actually paid for the gun. So be very, very careful about, if you find yourself in that situation, about fighting over things that probably in the grand scheme of things don't matter. I once had a client spend probably about $1,200 in attorney fees fighting over Ed Hardy salt and pepper shakers that he could have bought like 6 or 7 times over. And I talked to him until I was blue in the face and told him, please, this is crazy. Like, I'll buy you an extra set of salt and pepper shakers. And he and his ex-bride just would not let it go. And so they both spent about $2,500 over those. And I don't even remember what we ended up doing with it. But it was just, it's silliness. And so
you gave them one each, probably. That would be fun.
Probably, yeah. We ended up settling, but I don't remember like what we had to do and who got them. But somebody had to give up something to keep the salt and pepper shakers, and that's just silliness, guys. When we're preparing for hearings or when we're preparing for mediations, we'll always meet with our clients like weeks before. And I'm sorry, I know my screen's like shaking. It's windy out here. But we'll meet with our clients weeks before so that we can have those difficult conversations with them and set expectations. Because what I don't like is when people get emotional, like right when you're in the thick of it, and then you start having those issues. If we visit with our clients and we give them several weeks to kind of process like what's going to happen, then I have found that those silly issues tend to kind of not happen, at least not in our room. They're ready to get it done. They're ready to move on, and got to let some of that craziness go.
Yeah, and I like to have to talk with them. Let's use a gun since that's what we're talking about. But when we're going through that, it's you want the gun. Okay, the gun's worth $500. And if the gun's really important to you, how important to you? Is it worth $2,000 to you? Are you willing to give up $2,000 for the property to get this $500 gun? $1,000 or $5,000? Like, what's your number that this gun is worth to you, right? And then explain, in order to get that, they may have to give up more than what the gun's worth. That's what they want to do. But yeah, certainly we have those conversations ahead of time. They go on with a clear state of mind, know what's going on, and can hopefully make an educated decision, even if it's not the decision we would make.
Right. And like you said, I mean, obviously, you don't want to go through your relationship planning for a divorce. But if there are photos or text messages or videos or witnesses when those gifts are conveyed, then obviously that is going to be extremely helpful, because a lot of times, like when I go to mediation, I will have that evidence readily accessible, right? And I'll say, if they say, well, no, he wants that gun back, that's, his grandfather's or whatever, and I'm making an argument that it was a gift, I'll say, oh, well, here's the Instagram post where she said, thank you, baby, for giving me your grandfather's gun. I love you so much. And then we send that over to opposing counsel, and then opposing counsel kind of knows, like, listen, they have a pretty good argument for separate property. And so if you want her to now return her separate property, you're going to have to give something up, right? So just kind of be cognizant is when it comes to gifts, it's better to not go in with this sort of he said, she said type argument. It's better to have some sort of supporting evidence, and you stand a greater chance of getting what you want. Cool tools?
Yippers.
Okay, go for it.
Someone's video bombing her. That's okay. Your hair covers her up. Okay. All right, my turn.
It is.
Can my wife get half of everything I have based on the info below? Okay. I'm not going to read this, and I'm going to guess that you can't answer the question.
Okay, we'll read it.
Okay, my wife and I have decided to get a divorce. She makes 100K to 140K per year. K means thousand, Christina.
Okay,
I
thank
get
you.
only, you're welcome. I get only 20K per year from SFA. Can she take half of everything I have in retirement, pensions, personal bank accounts by law? Question mark.
Did you say that I could not answer this?
Yeah.
Why can't I answer this?
Well, because you have no idea where his retirement came from, when it was accrued, when he retired, how much is in his pensions, whether it's separate or community. You don't have any idea for any of that. And I believe those are all, correct me if I'm wrong, but I think those are all important to be able to answer this question.
Well, but that was going to be part of my answer.
So you're going to say you can't answer the question because, yeah, right. Okay, go ahead.
Okay, well, I am going to, yeah, we know nothing. Okay, so I would say, let's just assume, I think what he's talking about, Floyd, is the discrepancy in income. And that's why he's like, if she's making 140,000 a year and I'm only making 20,000, can she really take half of everything, right? And so I was approaching it from the context of perhaps everything is community property, or most of it's community property, and he's just pissed off because she makes so much more than he does. So I'm going to answer the question from the context of it is all community property. Okay, so let's assume that you guys, y'all have a $500,000 estate, and she makes that much more than you. I would say,
I wonder if she knows she's on Facebook already.
I can't answer. Like, I mean, out of all the places, like this whole area,
big area.
Yeah, it's huge. And this is where she decides to go. Awesome. Okay, well, hello, lady. Okay, so I still can't answer the question because there's not enough facts. It's going to be subject to discretion, right? And it depends. Like, are you guilty of abuse? Are you guilty of having an affair? Are you guilty of wasting community assets? And when I say you, I'm talking about the lower income earner, right? Sorry, I'm distracted by that lady. And so, oh, she's in my video now too. Okay, so it just depends. Let's just say it's a no fault. You guys just are not getting along and you decided to separate. I don't know, Floyd, a 55, 45 split? Maybe?
There's no way you can answer that without, how long have they been married? I'd say false in the breakup of the marriage, employability. There's clearly disparity in earning ability, which is a ground that you can use for, what's the word?
But he's receiving 20,000 from Social Security, so we might have some disability issues there, which means that potentially he would be eligible to receive a greater share of the estate. He may
maybe
be
spousal.
able, to make a claim for spousal support also. So I guess the answer is maybe. It's just going to depend. And I would definitely hire a really good lawyer to investigate all of the facts that we just discussed. Because again, going back to the whole separate property, community property thing, right? So if you had,
that window.
Don't say that, Floyd.
If this happens on Facebook Live, we're gonna have to take it down.
Yeah. Yeah, she probably needs to get off of that.
She's a private investigator.
I'm sorry?
You think she's a private investigator, like snooping on attorneys here at the conference?
Maybe. So going back to, stop distracting me, Floyd. So going back to the separate property, community property context, if she owned things before the marriage, or if you own things before the marriage, that's not going to be subject to division, so long as you can prove that you owned it before marriage, right? Anything that you guys acquired during marriage, the code says a just and right division, right? But everybody always kind of has this perception of just and right division automatically means 50-50. It doesn't necessarily mean that, right? It means based on your particular circumstances, what is just and right? What is fair? What is equitable? And so you would have to get with a good attorney to talk to them about all the stuff and why, how long have you been disabled? Like, are you able to work? All that good stuff. And then perhaps you'll be able to get a better understanding of if 50-50 is okay. But I would say if I were repping mom, I would probably be a little bit concerned. I would probably be a little bit more inclined to maybe give up some of the estate to get the case settled, so that way we weren't on the hook for spousal maintenance. So yeah. All righty.
So I think what all that boils down to is you can't answer the question.
Yeah, I think you're kind of right about that. Oh. Are you looking at this on Facebook Live? Because I only have one screen, and I can't do that. How
many screens do you think I have?
I don't know, but if you guys are asking questions or posting anything on Facebook Live, we're not seeing any of this. Okay, perfect.
Over there periodically, it's just Sarabia.
Okay, not just Sarabia, it is Sarabia. Hello, Daniel. The Sarabia. So, okay. Can the ex-spouse claim property given to you in Texas divorce decree saying he paid the taxes, so now it's his? I did not get paperwork, title, etc. from him and did not call him because I wanted no more of his manipulative bullying. The tax office could not find the land, so finally had to contact him. Was told by him he paid the taxes. It was now his. Interesting. Right.
Okay, so there's a divorce. She was awarded some property. It was never transferred. He paid the taxes. Am I understanding this correctly? And now she wants the property. Okay. No, I think the property is still hers.
Yes.
Well, you got to deal with this stuff after the divorce rather than waiting. He may be able to file a civil suit to recover the tax money. So no, it's your property. So what should have happened is he should have signed a special warranty deed at the conclusion of the divorce, deeding over his interest in the property to you. Additionally, we like to add what we call muniment of title language into our orders. They can also be filed with the property records. That has the same effect as a special warranty deed in case he didn't sign it. This is something your attorney should have dealt with before closing up your case, transferring this property. So I think what you would have to do now, I guess it depends on the language in the order, right? Hopefully there's language that required him to sign the special warranty deed. Then you would file a motion to compel or an enforcement, depending on how the language is written, to get him to sign that special warranty deed and then transfer the property over to you. If he wants to recover the money that he spent on it that he thinks he shouldn't have spent or that you should have spent, he can file a separate lawsuit to do that if he wants to, but I don't think it's going to be a part of this case.
Yeah, so that muniment of title language is so important. And so basically what it is in your final decree of divorce, it'll say that that wife is awarded the following property as her sole and separate property, right? But the important thing is that you have to have the correct legal description in your final decree of divorce, okay? And when you go to like the tax appraisal districts and stuff, they don't have the complete legal description on. It's like shorthand for the legal description. So you actually have to go and you pull the deeds, you pull the contract, you pull, I mean, deed is really what we look at. And from there, we take the exact language and we incorporate the legal description into your final decree of divorce. Somebody is jamming out. Was that Biggie? I felt like that was Biggie.
It may have been Biggie. And we're like 4 floors up or whatever.
Yeah.
Maybe that. Maybe that was him himself.
Oh. So it's important to have the correct legal description, because if you incorporate that correct legal description and you have a sentence that says that the what does it say, Floyd?
So that this document shall serve as a meaning of the title.
Correct. Something like that. It's like a little sentence. And from there, if you're having trouble getting someone to sign the deed, or if you don't want to deal with them, or if you don't think that she can deal with them, sometimes we have default judgments where we know we're not going to be able to find the husband to get him to sign the deed. We make sure we incorporate that language, and then you take your final decree of divorce down to the district clerk's office, or excuse me, county clerk's office where the property records are, and you file your entire final decree of divorce. And then that will serve to put everyone on notice that, in fact, this is your property. So I say go, hopefully that decree was drafted correctly and you can just go and do that. Otherwise, you're going to have to lawyer up again and do all that crap that Floyd said, and it sucks. Yeah,
everybody
back in the day, right. Back in the day, we didn't do like Floyd said, we wouldn't have what we call closing meetings, right? And so over the course of the past several years, before we close out a case, we have a closing meeting. And basically what that meeting is for us to look at the decree. All right, do we have all the deeds? Do we have all the withholding orders? You know, how's everything working out? Is there anything that we could have done differently to help you, et cetera? But it's specifically to make sure that all those loose ends are tied up, because what we don't want to happen is that we let a client go and then they end up in this situation years later and we have problems.
So that,
does he get his money back?
I think would be considered a gift.
That's what I'm kind of thinking too. So
they didn't have the present intent for it to be a gift.
I mean, but it wasn't his property, and he knew it wasn't his property. And that, so we're at marriage dissolution. It's a continuing legal education course, and that was one of the cases that they talked about today. Was actually, it's kind of on point. So the house had been awarded to wife at the time of divorce, and there had been a history pattern of family violence. She had vacated the residence, and she had vacated the residence, and husband just moved back in. And because she didn't want to deal with him, she just kind of let things kind of roll, and he was there and he was paying the mortgage. And then I think it was like 7 years later, she had filed a motion to enforce the decree, to basically say he has to get the heck out. And the husband was trying to argue like that wasn't equitable. Like, so he was making what we call latches arguments, that he had been making this mortgage payment, that she had taken too long to file suit, et cetera. And in that particular case, the court said, husband, that's her property, get the hell out, and you're not getting your money back. And he had paid the house off for her. I feel like that's just a little bit of karma. No?
Yeah, no, it is for sure. It is for sure.
Sometimes that happens. So yeah. I wouldn't be paying things just in thinking, oh, now I'm going to be able to get it. That's kind of stupid. So
sorry for husband. Yeah, for sure.
Yeah. Okay. Your turn or my turn?
My turn.
Go for it.
Can I sue my husband? Suing your husband is rude. Can I sue my husband for opening bank accounts, credit cards without my permission? So my husband has been opening secret accounts, that's rude too, under my name without my permission. I only found out after looking through bank statements.
Do you know the answer to this question? Because I don't. I mean, I've had it happen in cases before, but proving that they didn't know was an issue. And so we kind of just sucked it up.
I don't, right? But I feel like it would be more than just a lawsuit if it's open in your name, because in order for it to be open in your name, you would have to sign the documents at the bank, right?
I mean, that's typically what happens. At least when I've opened up bank accounts, yes.
And so he would have had to use her information and her signature, or purported document that appeared, or he represented to be her signature, to have an account open in her name. So then
But when I tried to open my accounts, I had to like physically go and like show my ID. Like we had to be present to do that for my bank account.
I've done them electronically.
Remotely?
Yeah.
Okay.
Um,
Credit cards, I mean, that's a different thing. Like I know for sure you can do that electronically.
yeah, but so if he's submitting documents like this that he's forging her signature on, I think it's criminal liability is there, right? And,
Yeah.
and bank accounts, I believe that would be federal type stuff, right? So can you sue him? I don't know what you would sue him for. Maybe damages if he ran up a bunch of credit card debt.
Attorney's fees.
Yeah.
Yeah.
Nah, we don't know. We're just making
Next question. Oh yeah, I'd have no clue. And I actually have a case like that right now that I'm looking into where the same exact thing is happening. So maybe I'll be able to answer that in a month or so once I do the appropriate research. But it's with that in the past when I've had that issue, it always becomes this issue where the wife says, I had no idea that he opened these accounts, and the husband's like, BS, yes, she did. And then it's kind of like well, how do we prove that you didn't know about any of this, right? And at the end of the day, when you guys get a divorce, if that account was set up in your name, the creditor is going to look to you for 100% of that liability, unless, like Boyd says, there's some sort of criminal charges. And I don't want to say unless, like they're still going to look at you for that liability, but you may be able to get some sort of restitution from your husband where he has to pay you back, so on and so forth. And so it's crappy because I know that there's some crappy people out there. But in the past, what we've done is we've taken that debt or that liability, and we've received other property to offset that liability. And we try to tack on extra for like interest, et cetera, because we know at the end of the day, you know, Chase credit card is coming after Our Lady no matter what. And so, yeah, you might be kind of SOL on that one.
Oh, before we go to the next question, a couple things. First, Daniel, I'm assuming on the one where that dude paid the taxes, he was looking at adverse possession. Maybe the husband would have an adverse possession claim.
Well, so that was 17 years ago in property of my first year of law school. So do you care to remind me what?
Well, yeah, so had they been divorced when you were in law school, he still would not have been there long enough to claim adverse possession. I believe it's 20
like
years.
10 years?
Not
10 or 20?
Like 20 or 25 years, yeah.
But there's something else.
Right, I mean, he comes up with things like that that are just off the wall. So good try, Rabia. We appreciate you attempting to participate, but if you don't have useful information, no. But seriously, so Corey Kano did ask a question. He wants to know what's considered child abandonment in Texas, and can you modify current orders without the mother being in the state? You remember Corey, right?
I do. I'm trying to think of the whole child abandonment thing.
So
Is
abandonment
that a
would be
thing?
so it's a ground for termination, which is the only way I think of child abandonment. If you
Yeah.
abandon, leave the child with another without providing support, all that stuff. It's a criminal
So,
offense also, but I don't think that's what he's talking about.
right. So I presume that maybe the fact pattern is, and I have no idea, but I'm just gonna go ahead and go out on a limb that mom hasn't seen kiddo for a very long time, and is maybe not paying child support and maybe not being participatory in any way, shape, or form. And if that in fact is the case, then you don't have to prove abandonment. Like there's no requisite time. There's, it doesn't have to be 2 years or 5 years or anything like that. What I think the court would look at, assuming that you're trying to modify, is he trying to modify possession, Floyd?
He's been out of state and out of his life for 4 years. All she says. He doesn't say. He just said modify current rules. I would presume, yeah. Where
Okay.
maybe mom has FPO and he doesn't want the child to have all that.
Yeah, so you can modify visitation, and that's going to be a best interest argument, right? So, judge, she hasn't seen the kiddo in 4 years. The kiddo doesn't know who this person is, or maybe doesn't feel comfortable with her. I don't know what she's doing, who she's with, where she lives, etc. And therefore, I want to terminate her visitation, or maybe just limit it to the state of Texas for a few hours at a time. With advance written notice of her intent to come and visit, that sort of thing. If you're talking termination, like that you want her just completely out of his life, there's like, I don't know, Floyd, how many, like 15 different bases for an involuntary termination, which means mom is not consenting to the termination. And the abandonment portion of it, it's, and I'd have to pull up the code to be able to make sure that I get it correctly, but it's something to the effect of left the children without care. What is it, Floyd? Do you remember?
Yeah. So if you left the child with another for a year without providing adequate care for the child, then there's another one that says failed to provide support in accordance with a court order for 12 months also.
Right. And so those are bases for an involuntary termination. I'm always really, really reluctant to tell clients like, okay, yeah, let's move forward on a termination based on those grounds, because that's what I consider like a death penalty, order, where if a judge grants that just because she didn't pay child support, this mother will never, ever have any opportunity to see her child ever again. And so I just think judges are going to be super reluctant to terminate based on that particular provision. And so, assuming that a termination is what we're looking for, I would probably file a motion to modify visitation, and also maybe a motion to modify the child support to increase her support obligation. And if she hasn't been paying child support, maybe a motion for enforcement. And then see if potentially we can work out an agreement on visitation, or maybe work out an agreement on a termination because she hasn't seen the kiddo anyway. Maybe she's like, yeah, that's fine. I'll terminate my rights. That way I don't have to pay child support and I don't have to worry about any of this stuff anymore. And then we could get a voluntary termination, which is much easier to come by in court.
So I'll tell you that on those termination grounds, there's some little nuances with those. Can't go into those right now because it's pending, and I don't know who's going to watch this. I've got to argue this before long, but there are some little nuances. So maybe in 6 or 7 months we can talk about how those work.
Excellent. Or you can just call us, Corey.
Right. Well, so he did clarify. He wants, looks like sole. They've got JMC. He wants sole managing. And so, yeah, if she's been out of his life for 4 years, the court would be more inclined to do that, to give you all of those decision-making abilities. Since she hasn't been participating in them, she doesn't know who the child's doctors are, things like that, to be able to make those decisions. But yeah, so go for sole, restrict visitation, all stuff that Christina talked about. But yeah,
right.
It's very possible.
Right. Floyd, I say we skip number 6 because I don't understand that question. Do you?
Does that constitute service?
As legal notice to the court?
Yeah, I don't understand. Yeah, you're right. Okay.
Okay. My turn to read?
Sure, go ahead.
Okay. So if the custodial parent goes to jail while the child is in my custody, can I do anything? She went to jail for DWI and felony evading arrest in a vehicle. She did not have the child, but since she's in jail, she has been having mental illness problems and the jail is evaluating her. Good question.
Yeah, so can you do anything? Absolutely. Right? You file a modification. Custodial parent, so that means there must be an order. Yeah, so file a modification. I would do extraordinary relief when she's in jail and given her offenses and potential mental illnesses, and go that route. So extraordinary relief is basically an emergency order that's encompassed within a temporary restraining order that would award you possession of the child. So if she does bond out, without that order, she can just go pick up the child. And if you did not release the child, then you could be in trouble for interfering with child custody or criminal offense or contempt from the court, which could result in jail time as well. So certainly get the modification filed, get the TRO done, and then go argue to become the custodial parent.
So, and I feel like we've had this come up before, where one parent's in jail, mom's in jail, and then like grandma shows up at the house and says, well, mom told me that she wants the child to stay with me while she's in jail. What say you, Mr. Floyd?
That mom, say that again?
So mom is in jail and mom tells grandma, I want the child to live with you while I'm in jail. And I have the exclusive right pursuant to prior order to designate the residence. And so I'm designating the residence at grandma's house.
She can do that.
Repeat that?
She can do that.
Right. And so if that were to happen and grandma shows up and grandma says, well, mom said she wants kiddo to stay with me. And if dad does not file that TRO and does not file a modification and does not release the child, then I think there's a pretty high probability that he could be held in contempt of court. So that's why it's important. Like when you find yourself in those situations, don't try to take matters into your own hands. Like you need to visit with an attorney. That way they can get you, started on the right path. And it may very well be like for strategic purposes, we don't file anything immediately, right? Like maybe mom is over the phone. She agreed to allow you to keep the kiddo. And so maybe we're just going to kind of get everything ready to file, but hold off on filing and see how long you can keep the child on a voluntary basis, right? With mom agreeing to it. And then if, Lord forbid, everything or anything happens and, it hits the fan, we have the paperwork ready to file and we move forward at that time.
What hits the fan?
Stuff. Sometimes it hits the fan.
It does. So going with your same example, how would you feel about mom designate grandmother?
Mm-hmm.
How do you feel about extraordinary relief in that case? Right, if the child's not in danger and possession of grandmother and winning custody at temporary hearing.
So the standard is the child's present circumstances would significantly impair the emotional or physical development. I say I would not want to represent dad in that case. I mean, that's a tough one. So that gets, I don't know, Floyd, that's tricky. And that's where it is so important that you know your judge, because I think that some judges might be inclined to still give the child to dad. maybe there's a standing issue for grandma, like, well, I guess it's not like grandma's trying to intervene. Um, so yeah, I mean, I think you file the motion to modify, and then mom's in jail, and so I guess mom's attorney could show up with grandma as a witness.
And mom could be there. They could bench her over.
They could bench her over.
You can't prove significant impairment.
Yeah. So maybe best
I feel like
plan.
this is one of those things that dad will win on temporary orders, although he doesn't get the letter.
I kind of feel that way too, but I also think so here's the thing, and this is very frustrating, and I just had a case like this where the attorney made a mistake, the other side made a mistake, and it's important that you understand the legal requirements at temporary and at final. Okay, so in most cases, you're going to have a temporary hearing, you're going to have a final hearing. Temporary hearing, you're typically going to have that within a couple of weeks to maybe 2 months, within that time frame. And at that time, if mom had custody in a prior order and dad is trying to take custody, dad is going to have to prove one of three things. The first is that the child's 12 years of age or older and child wants to live with dad, and they're going to tell the judge that in chambers. The second is that mom voluntarily relinquished the child for 6 months or more, and he's had primary possession, and then he can get the kiddo at temporary. And the third is a significant impairment element, where if the court does not move this child immediately, then the child's going to suffer some sort of harm, and therefore the judge needs to pull them out immediately for their own safety. Okay, so that's typically at temporary. Now at final, your burden is, in most cases, there's going to be exceptions to this, but your burden is best interest. And so in a case like this, what we might, from a strategic standpoint, think about doing is filing the petition to modify, not requesting temporary orders, getting mom served, seeing if mom's going to file any sort of an answer. And if she does not, then we can default her and get the kiddo that way. If she does, then we can try to quick set a final hearing. And because at the final hearing, it's just best interest. And clearly the kiddo is going to be better off with us than with grandma or with mom. And so we win that way. So, you know, I tell people all the time, especially during my consultations, and I know that if I were in a client's position, I'd probably be super frustrated at times. But when you're dealing with family law cases, it is never, ever, ever linear. Like, I can sit down and I can have the best plan that anybody could ever think of to help my client. But you know, Mike Tyson says everybody has the plan until they get punched in the mouth, right? And when you're dealing in family law, every day you're getting punched in the mouth because something happens, right? Grandma takes the kid, mom gets out of jail, dad gets arrested, dad takes off to another state, you know, and takes the kiddo with him. Like, all sorts of craziness happens. And so these are the types of things where we have case strategy meetings with the attorneys and sometimes the paralegals. And we say, all right, this is, if they do this, then we're going to do that. And if they do that, then we're going to do this. And you have to constantly be communicating with your lawyer so that y'all can make sure that you're not screwing something up. So
it's one of those situations where we want to kind of stick to our plan, but also pivot if we need to, right?
The stick pivot, yes, that's a great,
great
pivot.
way.
Exactly. So one more question.
Sure, it's good.
Okay, which one are we on? 8. Okay. So will I be able to get a lawyer to help me with my child support case that my child's father filed?
You want me to answer 2 in a row then? Okay.
Oh, go ahead. Sorry.
Will I be able to get a lawyer to help me with my child support case that my child's father filed against me? My child's father filed an enforcement order against me, stating that I was not allowing him to see the child since 2019. I have since then filed a written answer. We have court soon, and I would like a lawyer present with me because I'm not for sure how this goes or works, if we're being honest. And we are always being honest.
We are being honest. So Maybe.
Not at all a child support case.
I'm sorry.
Not at all a child support case.
It's not.
That was
No. It's,
misleading.
yeah. So I presume the prior order was like a child support order, and that's her confusion. But if they file an enforcement against you, so typically the rule is if you're subject to incarceration for 180 days or more, you have the right to be represented by counsel. And it's a quasi-criminal proceeding, and so it's just like in a criminal case. If you fill out an indigency affidavit and you represent to the court, hey, I don't have the ability to retain somebody to defend me, and obviously I don't want to go to jail, then the court can appoint an attorney to help you in an enforcement proceeding. And so, but it's going to be dependent upon your income, and just because you don't want to pay a lawyer, that's not going to be sufficient. Like, you literally cannot have to present evidence to the court to say, I cannot afford an attorney and this is why. See?
Yep, and worse than that, if you have in fact been denying dad custody for 3 years, good chance you may lose custody if a modification was filed.
Yeah, so I'll say we have a tendency to kind of do that quite a bit. So we're very clear with our clients. It's not good to deny visitation to a party, and unless you have legitimate, even if you have legitimate safety concerns, it's always best to follow protocol, make sure that you're following the correct things, or to at least consult with an attorney so they can tell you what to do. Okay. But a lot of times what we'll do is we'll follow the enforcement and the modification, and it depends on the denial, right? Like, if it was an isolated event, depending on the circumstances, you're probably not going to lose custody. But if it's for years and years and you're just like not being, and he's actually attempting and he can't find you, things like that, then yeah, you might lose. Why are you laughing at me?
Well, so they can't see all your little hand gestures. And normally when we're doing this, I can't see you, but you're like right there. And so I can see all your little hand gestures that they can't see. And I thought, I'm going to flip my camera to where they can't see you from this angle.
No, that would be rude, actually.
And I thought that would be really funny. And then I thought I probably should do it. But
no, you shouldn't do that. Yeah, no, thank you, Floyd. God bless America. Okay, so I'm going to try to share the disclaimer. All right, here we go. So we always state beginning, sometimes middle, and end of our event that you should not take this as any sort of legal advice. Like I've stated, go tell a good attorney your story, follow their advice, do what they say. Hopefully these events give you a little bit of information to kind of help guide you through some of the complexity of this stuff, and maybe give you a little bit of negative information so that you can maybe go and ask your lawyer, like, hey, I heard about this. Is this a particular thing? And then y'all move forward from there. But by all means, do not accept this as any sort of legal advice, because we don't know your story, and we would never, pretend to be able to give advice without knowing all the facts. All right. And as Mr. Floyd stated at the beginning, please, please, please go on to social media and follow us. We have Instagram, Twitter, Facebook. We have.
Well, don't they know we have Facebook if they're watching this?
I mean, it's a friendly reminder.
Oh, okay. Tricky on.
TikTok. We're on everything, guys. And so please, if y'all could go and follow, like, subscribe, do whatever it is that you do on those platforms, we would greatly appreciate it. And with that, have a happy weekend.
Toodles.